Very good afternoon. Thank you all for joining us today in this lecture class. I am Tulip, moderator for the session, and I'm deeply honored to have Mr. Vaibhav Kakkar and Mr. Snigdhaneel Satpathy as our esteemed speaker. Thank you all for joining us today in this lecture class. Mr. Vaibhav Kakkar is a partner at LNL Partners, dealing in corporate and commercial, M&A, PE, BC, and regulatory. He has nearly 15 years of experience with a unique mix of regulatory and transactional expertise and specializes in structuring transactions, especially cross-border, and advising on foreign investment, exchange laws, company law, securities law, TMT laws, and gaming laws. He has advised several global corporations on appropriate strategies in relation to investments and domestic and multinational clients on significant complex corporate matters, including cross-border mergers and acquisitions, joint ventures, private equity transactions, and regularly advises and works with the government on policy issues relating to company law, exchange control, and as a key member of the firm's advocacy and policy exchange development team. His recent accolades include being recognized as 40 under 40 outstanding legal professionals by Asian Legal Business for 2019, leading individual in M&A by Legal 500 in 2020, rising star by Legal Era, and highly regarded in M&A for 2020 and recommended lawyer by 2018 RSG report in the area of corporate and commercial laws. He also won the Rising Star Lawyers of the Year award at the Legal Era Gen Next Council Congress and Awards 2016. Mr. Snigdhaneel Satpathy is a partner at LNL Partners, corporate and commercial, M&A, and regulatory. He has operations on appropriate strategies in relation to investments in India and domestic and multinational clients on significant and complex corporate matters, including cross-border mergers and acquisitions, joint ventures, and private equity transactions. His unique mix of experience ranges not just on the transactional side, but also on complex regulatory issues, particularly from the perspective of foreign exchange law. He has in-depth experience with industry-specific legal and regulatory issues in sectors including defense, retail, real estate, telecommunications, gaming, hospitals, foreign contribution, education, mutual funds, education, and the financial sector. Banking and some of his marquee transactions include the merger of Ranbaxy with Sun Pharma, valued at USD 3.2 billion, which is the largest M&A deal in the Indian pharma sector. He's a much sought-after commentator on emerging legal issues in India, particularly on FDI and exchange control issues, and he frequently contributes articles to major journals. He's a regular speaker in the top law schools in India. Today's lecture class is on M&A deal making and documentation. This class is organized by Legitquest, which is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iRAF Case Analytics. In short, the iRAF feature, powered by artificial intelligence, takes you to the issue, facts, reasoning, arguments, and decision of a case law. It also has started with LegitI, which is latest news, interviews, and columns, and serves the stakeholders of judiciary. So today's session will be for 45 minutes, followed by a Q&A session. I would request all our participants to be on mute and without video throughout the session, and all questions to the speakers can be written in the chat box, which will be taken at the end of the session, if the time permits. And we just got to know that Mr. Kakkar is unwell, unfortunately, and we would see if he would be able to join us in the second part. If not, then I would request Mr. Satpathy to take the session forward. So now, without further ado, I would now hand over it to Mr. Satpathy. So please.
Yeah, thanks, Tulip. Good afternoon, good evening, everybody. Welcome to the session. We've prepared a small presentation. I've asked actually somebody. Tulip, if you can enable a screen share, that would be good.
Just 1 second, we're doing it.
Yeah.
I think it's done now.
Okay, thank you. Yeah. So, I mean, I won't take credit for this presentation. Somebody in my office has done this, but I thought it would be helpful to have a written document in front of us when we are talking about mergers and acquisitions and deal making and transaction documents. So, the first thing that we need to understand and is essentially how a transaction occurs or happens in a very sort of a limited sense. One of the first things that a lot of companies, especially the sophisticated companies on before doing any such transaction is to have a non-disclosure agreement. That's an NDA. And the reason why an NDA is super important is because this NDA not just contains, confidentiality clauses in any transaction, but also has various aspects in relation to exclusivity. I'll talk about each of these in a little bit of detail. So for us to suffice for us to know that the first issue that when two companies wish to come together to enter into a transaction is that both companies are worried about the information that will be flowing between these two companies, between the advisors of the companies, between the employees of these companies. And this is especially critical if these companies are operating in the same field, if these companies are competitors. We did the Sun Pharma Ranbaxy M&A a few years back, which was one of the largest M&As in India at that point of time. And the biggest challenge that we faced was essentially the inherent issues and reservations that these companies had in sharing information about each other. And the reason for that is very simple, that if tomorrow, for whatever reason, the transaction doesn't go through, then whatever information is being shared, whatever discussions are being had, a competitor would essentially be privy to all of those knowledge, will be privy to all of this information and can use it. So that's one of the biggest challenge that we as lawyers face. And so therefore, one of the first and the most important things that we do in any sort of transaction, be it an M&A transaction, be it a pure play private equity financial transaction, is essentially have a non-disclosure agreement in place between the parties. And this is important because without a non-disclosure agreement, you're essentially opening up your company to a person who wishes to invest in your company. You're opening up the information, proprietary information, confidential information about your company to third parties. And all of these become really important because then if for whatever reason the transaction doesn't go through, there is a competitive advantage that a party gets. So an NDA is something which is very important. Whenever we talk about, or as practitioners, or even people, who work in this sector, whenever people talk about mergers and acquisitions, all we think of shareholders agreement, share purchase agreement, but we cannot stress enough that an NDA is a prerequisite for entering into any transaction. So that's the first bit. Then comes the term sheet. Now a term sheet is essentially nothing but a rough piece of paper which sets out what are the broad contours of the transaction that is going to happen. The term sheet is not a transaction document. More often than not, it's not binding, but it has the broad contours or the broad agreements of what a transaction would look like, how a transaction would proceed, what are the basic rights that each party would be looking at getting. And the reason why such a term sheet is important is because it is at the stage of a term sheet that you understand where the minds of each of the principals are. If they're very different, if the two parties cannot agree on certain basic components, then it's a wastage to take the transaction forward, where you have involvement of lawyers, involvement of valuers, third parties get involved, employees get involved. It's a huge cost to an organization. So all of this can be prevented if you have a proper and well negotiated and well agreed upon, well sketched out term sheet, because then in that term sheet, you will at least agree on broad things. Now, the other advantage of having a proper, well fleshed out term sheet is essentially it reduces negotiations at the stage of documentation. If the rights are clear and if the concepts are clear at the stage of the term sheet and how the deal is going to proceed is clear, then all the lawyers are essentially doing at the time of documentation is drawing up the documentation. And of course, there will always be small points, minor issues, which may need to be negotiated. But the basic construct and the commercials of it are frozen. So therefore, at that stage, you're not looking at a fresh a fresh reinvention of the wheel of sorts at that stage of the documentation. Typically, we do term sheets in India which are non-binding in nature, except for certain clauses. And the reason why they are non-binding is essentially because uh, a non-binding term sheet doesn't create any rights, because you don't know at the stage of the documentation, there might be certain issues. Typically, a term sheet in India, and it's slightly different in the West, but at least in India, a term sheet is done before a due diligence of companies undertaken. In more mature jurisdictions like the US or the UK, Europe, some common law countries, essentially they all look at doing a diligence before doing a term sheet. And the reason for that is that in those sort of jurisdictions, companies, the information about the companies are quite public, and there are very little proprietary information, which doesn't really affect the contours of the transaction too much. But in India, especially investments happen, in private companies, which are not listed, and so therefore information is generally confidential and proprietary. So nobody wants to open up the company for diligence without having a term sheet in place. So that's a nuance, that's a difference that's there between how transaction may happen in the West and how it may happen over here. I have had the opportunity to work in a couple of law firms in London and US, and there this sort of a thing happens slightly different. The other pieces of the transaction, and I will talk about each of these in detail in just the next subsequent few slides. But the next few things are essentially you will have a share purchase agreement, you will have a shareholders agreement, and then there are certain compliances, etc., that need to be done. Now, in India, in a mergers and acquisition scenario, there are typically 3 or 4 types of instruments that people buy. That a buyer, the purchaser who is investing in a company, it would either invest in an equity shares, which is the most common one that we can think of, or in the alternative, it can look at CCPS or CCDs. Now, CCPS and CCDs essentially are instruments which, after a period of time, get compulsorily converted into equity shares. And typically, the reason why CCPS and CCDs are so common in India, because private equity players want a different category of shares so that they can have certain additional rights, which would not be there in an equity shares. In a mergers and acquisition scenario, where you will have 2 companies which are probably in the same field, so it's a strategic investment which is happening. Mostly, you will see equity shares being transferred from the transferor to the transferee. But as far as CCPS and CCTs are concerned, these are mostly preferred by private equity investors, by financial investors who don't really want management rights in the company, but are more interested in getting a financial value out of it. That's one of the major differences that you would see in a private equity investment and an M&A investment. That in an M&A investment, it's essentially more strategic. The buyers, the purchasers will have a more long-term vision in mind. So therefore, there are differences in how a document is negotiated, how rights are negotiated, which is slightly different from a financial investor. A financial investor would not care so much about getting control over the board or having a board seat, but they are more they want more dividends. They want a return on their financial investments. So that's the difference. So which is why CCPs and CCDs offer a better right to them, because they essentially have some form of a liquidation preference, which is basically a protection of the investment amount that they have invested in the company. And then, of course, the last part is share warrants, which are similar to essentially shares which get converted, which are warrants which get converted into shares upon certain trigger events or post whatever period that may be commercially agreed. So typically in India, these are the 3-4 different types of instruments which somebody would use to invest in a company in India. In an M&A scenario, especially where it's a strategic M&A, you would mostly see equity shares, and which are the most common currency for investment. Whereas if it's a private equity investor, then mostly you would see CCPS and CCPs. Now, I'll come to the various aspects on the NDA. Now, the first thing, if you can see the slides that we have prepared, one of the important things that needs to be kept in mind is that the information that will be shared can include business plans, financial statements, projections. Now, all of these would be relevant because this would help the acquirer in evaluating the terms of the deal, the commercials that will be there. Now, as a part of sharing all of this information, there is an analysis which ends up happening on what are the strengths and weaknesses of the company. And especially if it's a competitor, then that becomes a huge information sharing exercise which somebody or which a company can gather. So imagine a scenario if, say, a SpiceJet and an Indigo were to decide to merge with each other, where SpiceJet would essentially be the resultant entity. So SpiceJet would be looking to do a due diligence on the Indigo or on Indigo. And if it's an equal merger and acquisition, which means that both the companies come together to form a third entity, and the shareholders of both the companies essentially get shares in the third company, then the information which will be shared would be essentially from both sides. So which means that Indigo would have information about SpiceJet, and SpiceJet would get information about Indigo. Now imagine in such a scenario where you would essentially know about ongoing strategic and operational issues, what are the different business plans that the company may have, what are the projections like, what are the new features that they plan to introduce. So all of these information would then become available to the competitor. So to prevent them from using this information, a very well thought out and a tight-knit non-disclosure agreement is important. It's as a practitioner, we can tell you that it's extremely negotiated. Lawyers from both sides negotiate this to make sure that this is something which is as watertight as possible. And it's also something that cannot be misused. So these are the important aspects to bear in mind while somebody is negotiating a non-disclosure agreement. Next, we come to the term sheet. I've spoken briefly about what a term sheet would look like. There are certain key terms which a term sheet has. One is, of course, the proposed structure of the transaction, whether it's an asset purchase, whether it's a share purchase, whether it's a merger. All of this will be set out in the term sheet. What would be the broad commercials, which basically means whether if there's a purchase price or if there's a adjustment in a purchase price, all of that would be set out. Now, it's an important concept, which increasingly we are seeing that, the purchase price that is actually being set out in a term sheet is often pending diligence. So imagine you decide that you're going to buy a company for 1,000 crores based on the market capitalization of the company, based on the public information that you have. I beg your pardon, the valuers have decided that the value of the company should be about 1,000 crores. Now remember, it's post this term sheet that you're going to undertake a diligence of the company. Now, once you start with the diligence of the company, you realize that there are 4 litigations or 5 litigations which has the potential of eroding the valuation of the company by 100 crores or 150 crores. Or you realize that there is a debt in the company which nobody spoke about before this, and that debt is worth 100 crores. So therefore, you keep these clauses in the term sheet where you take certain basic presumptions and assumptions that the enterprise value or the valuation of the company would be X rupees or X dollars, depending, and this valuation would be premised upon the company not having any debts outside its ordinary course of business, not having any litigation. And in the event any of those litigations or debts, etc., which are present, then the enterprise value would be adjusted appropriately. Now that's a purchase price adjustment clause, which typically finds presence in a term sheet. And it's very important to have those. As lawyers, mostly we would not be really looking into the commercials of it, of how much value, etc., that should be provided. But often you will see that, especially it happens in the startup scenarios, that these startups would become really valuable, but they would not have much deal experience, or the personnel there would not have a proper deal experience. So they would come with a term sheet which is very sketchy, which is very basic. So it's important to at least set out the concepts so that they understand that these are the different things that can happen. Of course, you will always be guided by what the client wants. It would depend upon the facts and circumstances. Each transaction, as I always tell my associates, that each transaction is different. There are nuances which are different in each transaction. So there is no one size fit all. But these are some of the important concepts that one needs to know. The next important aspect that comes in a term sheet is what is the nature of the consideration that needs to be paid by the buyer. Is it cash? Is it shares? Is it a combination thereof? It can be anything. Especially in an M&A scenario, we have seen instances where it has been a part cash, part shares deal. So those are extremely complex, but that needs to be set out in the term sheet as to how are you planning to pay the seller the amount of money that they may require. I mean, that they decide is the valuation of the company. It could be by way of shares. It could be by way of cash or money. If it's cash and money, then who pays the taxes? All of these are critical points to be taken care of, to be noted. I beg your pardon. And needs to be set out in a term sheet. Then the next part is, of course, the diligence. One needs to set out very clearly what is the type of diligence that you will conduct. The documents would have to be in a particular format, because if the documents are in a local language that we can't understand, then that sort of defeats the purpose. So that's the diligence process which is set down. What are the various typical condition precedents that needs to happen before the closing of the document, before the closing. For example, typically, if there are certain non-compliances in the company, that needs to be rectified. If there are certain issues that are found out through the diligence exercise, then those need to be sorted. So those aspects are really something that would go towards CPs of closing or condition precedents to closing. If there are certain additional rights which the new buyer or the investor is getting, then those sort of rights would have to be taken care of in the articles of the company. So these sort of things become important. And these sort of things also, are set out, at least in a sketchy way, in the CP, saying that, we will come out with, with proper CP schedules as and when the diligence has happened. Then there will be, the next important parts will essentially be the, non-solicitation and the non-compete provisions. And these are again very important because what happens is that these sort of, transactions, they don't happen in a day. A typical really fast track M&A deal, from the day you start discussing till the day you sign the documents, would typically be 3 to 4 months. I mean, and this is something, I'm talking about a big ticket M&A, of course. And 3 to 4 months is a really, really aggressive and fast timeline. So in those 3 to 4 months, there are ample opportunities for the seller to go around in the market and essentially seek for more buyers, so that you're essentially starting a bidding war. So it's important to have these non-solicit or no-shop exclusivity provisions within the term sheet, which would say that during the pendency of this term sheet, there would be no other negotiation with any other parties. This is important. And, remember how I suggested that term sheets are typically non-binding in nature. The exceptions to that is this non-solicit. The non-solicit provisions are always binding in nature. Basically, if you have signed up to a term sheet and if you are the purchaser, it's incumbent upon you to make sure that you advise your client to have a non-solicit binding clause in the term sheet, which would prevent the seller from going around and shopping for additional buyers. Of course, if you are the seller, then this is not something that you really care about so much. But yeah, if you're a buyer, it's critical. The next part is essentially on expenses. Who pays the expenses for the entire transaction? Typically, it's shared between parties, but then we have seen all types and depends upon, frankly, the negotiations that happen. It's a commercial point. Indemnification is the next point. What happens? What all indemnities would an entity be providing? The shareholders be providing. The sellers would essentially be providing indemnity. I'm presuming most people over here would know what an indemnity is. It's essentially a promise to make good any loss that happens or that arises out of the transaction based on certain promises that are made by the seller. So which in simple words, any transaction is happening because a purchaser wants to buy something on the basis of certain promises which are made by the seller. So seller makes a promise, premised on those promise, a buyer buys a company, buys a shares, or something of that sort. If any of those promises are found out to be untrue, then the buyer is entitled to certain damages or certain losses and certain claims. These are essentially indemnities. Any claim that a purchaser may have due to a breach of a promise is essentially indemnity. So these sort of things are set out in the term sheet. They, of course, a term sheet is not a transaction document. So a lot of minute detailing around each of those constructs happen in the transaction documents, like the SHA or the SPA or the SSA. But the term sheet at least lays on the broad construct. Now, these are some of the learnings that we have had over the years on how a deal structuring is done. Now, remember, whether a deal or how a deal documentation happens is entirely dependent upon the transaction structure. If and for us to identify how the deal structure would happen, there are essentially three important things that we need to understand. One, what is the primary objective of the parties? Two, how do you appropriately structure it to achieve that primary objective? And three, how do you minimize risks for all parties? Now, in a mergers and acquisition scenario, what is the primary goal of the parties involved in the transaction? The primary goal is for two entities to combine together in a manner such that you have synergies, such that you have competitive advantage, such that you do not fall foul of any anti-competitive law, or the CCI is not going to get adversely affected by it. It's not anti-competitive. It has to be a taxation efficient structure. So all of those come into play in deciding as to, for example, whether the resultant entity would have shareholders from both the companies or whether it would be an all cash deal where the current shareholders of the transferee company are paid in cash and the company is then taken over by the transferor entity. So that those sort of transactions or those sort of structuring happens depending upon what the deal structure is. In a typical normal private equity investment, whether the deal would be an equity deal is something which would depend upon whether it's a strategic investor or a private equity investor. If it's a private equity investor, the chances are that you will see a CCD or a CCPS instrument. The other important thing that needs to be kept in mind is, whether the deal is happening because the existing shareholders wish to sell out their shares or whether the company intends to raise money. So depending upon that, it could be a primary or a secondary transaction. A primary transaction is essentially where money is put in directly into the company, and the shares are issued by the company. So therefore, the shareholding of rest of the current shareholders go down, and the new shareholder who comes in, they essentially take up a portion of the shares which are issued by the company, and the company gets money, gets funded, and they use this funding for, business expansion, whatever. The other is a secondary transaction where the company does not get any money, but the current shareholders of the company are selling off their existing shares to a new investor, and they come in and take position in the company. So there are transactions where it's a combination of both primary and secondary. It frankly depends upon what is the objective. So that's the first step. The other, important aspects if an M&A transaction would be, especially post closing, what are the, in a scenario, in a typical scenario, and this is something which we see in companies which are very IP heavy companies, like a pharma company or a defense company, where there's a lot of intellectual property. And often what happens is that these intellectual properties are vested in actually the promoters and not really the company. So post-transaction, post the merger, one of the important things that ends up happening is that you transfer all of those important intellectual properties to the company, because frankly, that's the value of the company. Or if there are technical people who you know or who you believe understand the business and would be required to continue the business, then those sort of people you would wish to retain. You might wish to retain the promoters because you don't want them to go to the market and start their own ventures. So that's the other thing, that those are the other things that you look at. Now, what are the different types of deal documentation? Of course, you have the SPA, which is share purchase agreement. This typically happens in a scenario where you have the primary purchase, or it's a secondary transaction where you're purchasing shares from existing investors. A share subscription agreement, or an SSA, is essentially a document where you're investing directly into the company and the company is issuing shares, and as a new investor, you subscribe to those shares. So the funds are provided to the company and company uses those funds. It's a primary, you also call it a primary transaction. A business transfer agreement is slightly different, where you're not buying the company, but you're essentially buying the business of the company. So while there is no exchange of shares, but it's essentially you buy the assets of the company and you pay the shareholders of the company, or you pay the company for those assets, and the company then distributes it through a dividend. The scheme of arrangement is something which you see in a merger and acquisition. This scheme essentially, in most cases, needs to be approved by the National Companies Law Tribunal. It's essentially the broad contours of how a merger and amalgamation happen. It's a document which is akin to a process chart or a flow chart of how parties intend to have a scheme of arrangement, or how parties intend to have a merger and acquisition being done. This needs to be approved by the NCLT. In certain exceptional scenarios, especially where you're talking about mergers of a wholly owned subsidiary with a parent, the Ministry of Corporate Affairs, ROC, can also give that approval. Next is rights of acquirers post acquisition. Now, this is something where you look at SHA, which is a shareholders agreement, where the existing shareholders of the company come together and draw out a document which sets out the rights of them. This is the document where typically you will see discussions on how boards are going to be constituted, how many board of directors would be there, who would have the ability to nominate and appoint those board of directors, what are the protective rights and the AVMs that will be associated with each investor. Typically, if you are a private equity investor, you will want certain protective rights, which basically means that certain decisions of the company cannot be taken without your approval. So those are called protective rights, or AVMs, affirmative voting matters. And these are all discussed and negotiated upon and agreed and set out in a shareholders agreement. Of course, the other agreements are, the IP assignment agreement and the employment retention agreement. This sort of ties into what I was speaking earlier, where in a IP heavy company like a pharma or a defense, or a scientific research R&D company, the intellectual property is the main value. So therefore, the IP needs to be assigned from the existing company to the merged entity, the resultant entity. So that's something which also people look at and try and provide. Now, the broad contours of an SPA, we discussed some of this, but basically, reps and warranties is an important point. Reps and warranties are essentially promises which are made by the company and to the purchaser, which talk about the general health of the company. It could be, there are broadly three types of reps. One is a fundamental rep, which are essentially related to the title of the shares of the company. Then there are business reps, which relate to the actual business operations of the company, and there are taxation reps. Now, these reps and warranties are essentially backed by indemnities, which basically means that if these reps and warranties are untrue or become or are said to be false, then these reps and warranties are then these indemnities are triggered and payments are being made. Now, typically we see that there are caps on those reps and warranties which operate as a function. Caps on indemnities which operate as a function or a percentage of the total purchase consideration. We are increasingly seeing that big ticket investors, private equity investors, are wary that in the event there is a breach of reps and warranties, given India's court, given India's judicial system, it might be very difficult for them to go and enforce any right. So, rights in relation. So, insurance, reps and warranties, insurance is something which is actually gaining prominence. And these insurance agencies provide an insurance that in the event of any breach of reps and warranties, they will pay the sums. And typically it's a function of negotiation, but the sellers who are providing those reps and warranties also pay for those insurance. Now, I want to just, I know we are running slightly behind schedule, but I just want to quickly talk about the deal documentation as far as shareholders agreements are concerned. Now, apart from, the typical board seats, the board rights and the affirmative voting rights that are there are other important issues or aspects which are dealt with in the shareholders agreement. And perhaps the most important one are transfer restrictions and exit rights. Now, transfer restrictions are important because remember, when an investor is coming into the company, more often than not, in the context of India, these are private equity investors. These private equity investors don't have a lot of technical knowledge in running the company. So they are coming on the basis of the promotions or the promoters continuing to hold shares in the company and continuing to remain a part of the company. So therefore, there are transfer restrictions which are put in the promoters, in the form of lock-in, etc. Second, the promoters may also want to ensure that the investors who come in the company do not really sell off their shares to a competitor, because that would then mean that the competitors, a larger competitor, would essentially come and take up over the shares of the company and then decide to do whatever they wish to do with the company. So therefore, there are these restrictions on competitors. Of course, there are certain exceptions to that. And those exceptions are, if, for example, a private equity investor invests in a company with the notion that they will essentially get a right to exit after a few years. Once that right and has not been exercised for 7 or 8 years, or the promoters have not been able to provide them an exit, then they would need to exit for them to enable getting the money back which they have invested. A private equity investor is essentially looking at a financial profit. Private equity investors, mostly in India and across the world, are essentially funds who need to pay back money to their ultimate limited partners who are sitting all over the world. Now, for them to be able to do that, at the end of the fund term, they need to exit the company. If that exit hasn't happened, then in those scenarios, sometimes private equity investors, the financial investors, are able to agree on an exception where they can sell to competitors post 7 or 8 years or 5 years, whatever has been agreed, if no exit has happened till then. Next come preemptive rights. Preemptive rights are essentially, the ability of a company or the investors to maintain their shareholding, which basically, sort of means that if tomorrow shares of the company are being offered to somebody else, then first they will be offered to the existing shareholders and only then to the rest. So there are these sort of ROFO and ROFO sort of, concepts which are there. Dispute resolution, again, something which is very important. Typically in India, we see arbitration clauses. Mostly in India, people prefer foreign jurisdiction, and the reason being foreign jurisdiction arbitrators are more inclined on enforcing contractual rights vis-a-vis Indian ones. So that's something which which plays in the mind of foreign investors before they invest. And of course, an institutional arbitration is always better. I mean, it's more expensive for sure, but it's always better because you have standard terms of rules of engagement. An ad hoc arbitrator can essentially come up with their own rules of arbitration, which then becomes slightly difficult. CPs and CS essentially are various conditions that needs to be fulfilled before a deal is closed. Typically, a CP would essentially be either of certain non-compliances that has been identified during a diligence, and it's an obligation which is put on the company to rectify those condition precedents. Of course, if that condition precedent is not fulfilled by the time the closing is supposed to happen, then at the sole discretion of the investors who are putting in money, then they can decide to waive that CP. Absence of MAC, again, a very important issue. And this is something which we sort of saw playing out live. MAC is essentially a material adverse consequence. So if, for example, there is a material adverse effect that happens in the transaction between execution of the deal and closing of the deal, then whether somebody has the ability to pull out or not is something that needs to be very well legislated. I don't know how many of you are aware, but Louis Vuitton was essentially looking at purchasing Victoria's Secret recently, and they had a clause, or rather they did not have a clause which allowed them to pull out in the event of a MAC. And MACs are essentially defined as certain thresholds basis. If there is a decrease in revenue, or if there's a decrease in business below a certain threshold, depending upon certain adverse conditions, then it's called a MAC. And essentially, the valuation which Louis Vuitton had offered to Victoria's Secret no longer made sense because of COVID. But because they did not have a MAC clause, therefore they could not walk out of the deal. I mean, they did, but now it's being arbitrated. So it's important that any transaction document that is being negotiated, MACs are properly negotiated, because you never know what might happen. And once there is a MAC, then the deal may not make sense. But if you have already signed it, you cannot back out of it in the absence of a MAC. So as a seller, it's important for you to keep a restricted MAC, because you don't want the purchaser to use it and trigger it for anything and walk out. But as a purchaser, you would wish to have the MAC as broad as possible, which gives the purchaser the ability to walk out of the transaction if things go south. Reps and warranties, we discussed. Indemnities, again, there are a couple of, apart from those fundamental indemnities, apart from those fundamental reps, business reps, and taxation reps, there are indemnities which are backing those reps. Now, indemnities are typically of two types. One is a general indemnity, which will apply to any breach of reps and warranties. And the next is a specific indemnity. And these are, in your diligence process, you may have found certain non-compliances, and you know that tomorrow there could be a problem, or there could be an adverse penalty or a fine that could be levied. Those sort of things you specifically call out in the document and suggest that in the event these sort of fines are levied, then that's an indemnity event, and the sellers would have to pay for it. So that's there. The nature of scope of indemnity obligation, again, something which needs to be calibrated very carefully, because frankly, this is the recourse. if something goes wrong as a purchaser, this is the recourse. If you are the seller, you want to make sure that the indemnities, the procedure is as tight as possible, as narrow as possible, because you would want to have complete clarity as to at what stage the purchaser can ask for those indemnities. Now, there are certain deal-specific nuances within those indemnities. One is the de minimis threshold, which is basically a threshold where if something is 100 rupees or 200 rupees or whatever is the minimum amount that you think of, anything which is lower than that, then there are no indemnities if there's loss because of any breach of reps and warranties. There are caps, which basically means that irrespective of what the ultimate loss may be, it cannot go beyond a particular threshold. Time limits for claiming indemnity claims, again, for example, something like a tax indemnity, typically you would see a 7-year horizon because tax authorities can go back till that phase. So these sort of things, these sort of issues, I think are points of negotiation. These are covered in the transaction documents. These are very well negotiated clauses, indemnities. So those sort of things are important to keep in mind when one is working on this. Quickly, we'll just talk about the negotiation strategies. Sorry, am I audible?
Yeah, you're audible now.
Yeah, sorry, I'll just quickly finish. I think there was some issue with my connectivity. Just give me 1 second. Yeah. So, one of the few things that we need to keep in mind is that it's important to understand what the opposite party wants. What is the standard which is there in the market? You can't be negotiating from a position which is absolutely irresponsible. For example, I'll give you guys an example right now. We were negotiating the transaction, we were negotiating the Tata Boeing Defense joint venture, and this is all public, so I can talk about it. We were for the Tatas, and Boeing was for US. Now, Boeing lawyers, I don't want to name the law firm, but it was it was a London-based law firm. They were negotiating from a position which could have been standard in US, but was not standard at all as far as India is concerned. We actually ended up negotiating the document for almost 9 months because the starting position of Boeing was so ridiculous. It sort of created a lot of problems for us to agree to a middle ground. Remember, if we start off negotiating from a position where that for us to walk back it will take us some time, that sort of really creates a problem. So I think that's something which we sort of always try and provide, or that guidance, something which we always try and provide to our clients. Force majeure M&A deals, we just okay. From my side, I know that we are running a little bit late, but if there are specific questions which you guys have, then I'm happy to sort of take them.
Yes, so there are a few that we have received. So thanks a lot for that session. The first question is that what are some of the recent legislative changes that have impacted the M&A activity in recent times, especially changes that are brought up with respect to regulatory approvals, say RBI, SEBI, or CCI?
So that's a very interesting question. I think one of the important things for us to remember is that the very recent one that we can think of, and this is something which is actually creating a problem as far as we are concerned, is the Press Note 3. I don't know how many of you are aware of that or not, but basically because of the India-China issue, the Indian government essentially came up with a press note which provided that for any investment or foreign direct investment which happens from any of the neighboring countries of India, you would essentially need an approval from the government. Up doing is that various companies, or over the last few years actually, there has been a massive influx of FDI from China. The likes of Tencent and the likes of Alibaba have invested in almost all of the major startups that you can think of, be it your Swiggies or Zomatos, the Dream 11, all of that. I think it's something for us to importantly know that because of this, there has been a flurry of activity because entities have started now trying to bring down their Chinese investment below 10%. And the reason why this 10% threshold is important is because, if you know, under the Companies Act, the significant beneficial ownership rules, there is a 10% threshold for you to be considered a significant beneficial owner. So while there is no clarity, the government hasn't said that what is the threshold which will be important to determine as to whether a company would be deemed to be, quotes, Chinese or not. But 10% is what the market view seems to be. So that's a problem. That's creating that's creating issues both ways. We are seeing relatively less Chinese participation because we are aware that till now about 180 or 190 applications have been sent to the to the Ministry of Commerce for approval for these sort of acquisitions, but none of them have been approved till now. That's one side of the story. The other side of the story, of course, is that this Press Note 3 has also meant that entities like Dream 11, and this is something which is now in the news because IPL and Dream 11 is, of course, one of the sponsors. Dream 11 actually had as Tencent as their investor, and I was the lawyer for Tencent when they invested in Dream 11. And now, and they, I mean, their shareholding was slightly above 10, which they have now sort of brought it down below 10 because of this whole issue. And again, this is again public information; it's public knowledge, so I'm sharing it with you. But so both sides, there is some restriction on acquisitions that we are seeing because of this Press Note 3, but there are also increasing exits which are happening. So that's one thing I think that's relevant and important. The other thing is we know that the SEBI is looking at allowing entities to invest outside, list outside India. That foreign listing is again something which right now we are still working on. In fact, me along with Vaibhav, we sort of we regularly advise the Ministry of Corporate Affairs on these guidelines, and the current guidelines don't really adequately address the issues because what they've ended up saying is that if you want to list outside India, then you also have to list in India. So this concept of dual listing is creating some problems, but if, as and when that gets done, we will see a lot of listings, a lot of M&A activities that can happen. I was personally working on a big pharma merger where the deal did not finally go through because the company in India was to be listed outside India, and that time there was no regulatory framework. We were trying to sort of get a specific permission and approval, which didn't come through. So that didn't happen, but that's something, as and when that sort of comes through, we'll see a big change in this space.
Okay, so thanks to that. The other question is that how to avoid operational hiccups and monetary losses post a deal. What are some of the common mistakes that are made by foreign investors dealing with the Indian M&A market, and how can they be avoided?
Yeah, I think one of the most common mistakes, or I mean, I wouldn't call it a mistake. I think it's a cultural thing. One of the most common things that a foreign investor fails to sort of appreciate in India is that the judicial systems in India are not really geared towards enforcing contractual rights. So, you can have things written on your contract, but any litigating lawyer worth its salt would know that for you to actually get those rights enforced is a humongous task. So it's important, therefore, you have an escrow mechanism, which is what we always advise our clients, that please have an escrow mechanism, where a part of the purchase consideration, right now up to 25%, you can keep that in an escrow, which can be kept in an escrow up to 18 months. So at least, if there is any loss in the company because of any false promises made by the promoters, then that's something you can utilize to pay the indemnity for yourself. That's one. The other common mistake I think foreign investors end up doing is, they end up hurrying a transaction. Once you hurry a transaction, a lot of common mistakes creep in. For example, you will have a tight-knit shareholders agreement, but it will not be reflected in the articles of the company. And as we all know, if something is not reflecting in the articles of the company, then the company is not bound by it. So all your provisions relating to restrictions on transferability of shares, or having affirmative voting rights, are practically meaningless if the articles of the company don't reflect it. So these are I think, the two important ones which they miss out, because they believe that once it's there in the contract, which is the shareholders agreement, uh, then they can sort of get it enforced. That's often not the case.
Okay, thanks for that. Now, the other question is that how much of a role can be played by artificial intelligence as well as documentation with M&A documentation?
Look, I think as an M&A lawyer, I'm competing with an AI. But no, I think jokes apart, look, I think artificial intelligence, as far as documentations are concerned, um, I started this session by saying that every deal is different. But is there a standard documentation which is possible? Yes. And there are only incremental changes that happen on that. But then that standard documentation is something which the Indian legal market now has already figured out. So, if you, Tulip, it's been almost, it's 10 years since I've been practicing in this area. When we started off working in this, there was no standard documentation. So everybody had their own different documents and own different documentation. So it was difficult, because it was, when you're looking at a document, it's challenging. That exists till date, of course. But to a large extent, various clauses are standard. You know that this is something that needs to be put in. And of course, there are incremental changes to that depending upon the nuances of a deal. So as far as documentation is concerned, I'm not certain how much an AI can help. What I think an AI can definitely do is assist in the diligence process. I think that is something which an artificial intelligence, if properly, in fact, we have in our firm as well, we have seen a few instances where we have, utilized artificial intelligences to do a diligence. The problem is that currently they are not as sophisticated, and there's always this trust issue which are there, which will never go away unless and until it's utilized more and more. But at least in these law firms for the next 5 years, and I can only talk about a 5-year horizon, because beyond that, frankly, the world is changing very rapidly. I don't see an AI replacing your associate who will be burning the midnight oil to do a diligence.
Okay. Okay, so thanks to that. The other question is, what are your views on the cross-border demerger regime in India in light of this?
Sorry, Tulip, you'll have to repeat that.
Yeah, what are your views on the cross-border demerger regime in India in light of the Sun Pharma demerger case?
The cross-border demerger in India, frankly, is a myth. There's nothing like a cross-border demerger in India. What you essentially have is a demerger which happens because somebody sells off a part of a company in India. In India, look, what is a merger or what is a demerger? Merger is essentially when two companies come together to form a resultant entity. And a demerger is essentially when two companies which are together are separated. Now, when you say a cross-border demerger, the true sense of it is essentially where a company which has assets in India as well as abroad, they are made into two separate companies. Now, that doesn't happen in India. There is frankly no regime for it, because the RBI and the Companies Act and the Company Law, the Ministry of Corporate Affairs needs to come together to form a regime, because remember, holding and disposing of assets outside India by a company in India is not only governed by Companies Act, but there are also implications under foreign exchange laws. So therefore, that becomes important. So Sun Pharma, I've always told people that Sun Pharma demerger is a misnomer. It's basically just a situation where, a company or a company, of course, a company which was there in India, it sold off a subsidiary outside India. I mean, that's essentially it. I know the papers sort of mentioned it as the Sun Pharma demerger, but that's not really the case.
Okay, so thanks for that. This is the last question. Given the pandemic, what according to you does the future hold in the post-COVID world in this field?
Given the pandemic, what?
What according to you does the future hold in this post-COVID world in this particular field of M&A?
Look, I think a couple of sectors will definitely do well, and we are seeing it. There are lots of gaming companies in India, online gaming companies, which have done remarkably well. And there are lots of deals in that zone. We just closed the MPL, the Mobile Premier League funding round, where we represented Sequoia and Gojek. So that's an area. We know that there are a couple of other companies also which are in the process of raising funds. I don't believe that this sector is going to suffer, frankly, because during this period, when you don't have other companies sort of going up, you will have these sort of online companies which are doing remarkably well, and you will see a lot of consolidation happening. The other area, of course, is pharma. There are quite a few deals which are happening in the pharma sector, which, where private equity entities are lapping up these entities, especially in India, because remember what we lack in R&D in India, in the pharma sector, we sort of make up by our manufacturing capability. I think along with China, we are one of the largest manufacturers of drugs and vaccines. So that's again something where we are seeing a lot of activities. Big private equity investors like Carlyle's of the world and the KKRs of the world have started investing money in this sector. Pharma typically in India had always been a domain of strategic investment. The Abbott deal, which we did, or the Mylan deal, again, with something that we worked on, Baxter. So all of these pharma companies were entering into transactions with other pharma companies. I think that's been one change of this pandemic, that we now see private equity investments in these pharma companies. In the long term, frankly, I don't believe that there is going to be a lot of change in the M&A space, at least, because M&A in India has never been something which happens a lot. Mergers, especially acquisitions, yes, there are a lot of private equity acquisitions, a lot of acquisitions that happen otherwise in financial investments, but strategic M&A in India has never been a sector which has happened, which historically a lot has happened. And I do think that even post the pandemic, whenever that gets better, and I'm hoping and praying to God that it gets better as soon as possible, but whenever it does, I think that we will sort of go back to that curve, of course, provided, the economy also generally has a part to play with it. So that's that. I think, Tulip, I see one more question on the assured returns to non-residents while complying with FEMA.
Yeah, FEMA, yeah.
I think, so that's the last question. I think, so there are a couple of ways to do that. As we all know, right now, assured returns technically is not permissible. If there are call and put options in any transaction document, you need one month, or sorry, it's a lock-in period of 1 year. But even then, the return cannot exceed fair market value because there are pricing guidelines which are there. So how typically this happens is, in the transaction document, there are soft obligations which are taken that the parties will work together to make sure that liquidation preference or something of, or the investment amount is returned to the investor. If for whatever reason it is not possible, then parties will work together to devise other mechanism. And when they say devise other mechanism, what it essentially means is that there will be fresh issuance of shares at that stage. Practically, I'm saying how this works out. There will be fresh issuance of shares, the foreign investors will take up those shares, and the other investors and the other shareholders will not take up, will relinquish those shares. So which means that the total percentage holding of this particular entity, or the foreign investor, would actually be higher than what it has invested in. And typically this, because it would be a rights issue, so therefore this would, because this will be a further issue, preferential, so it will be a rights issue, so everybody will technically have the opportunity to participate but will not end up participating. So the foreign shareholder will take up those shares. So say they had 30% shareholding in the company, and if everybody picked up their shares, they would have remained at 30%. But because now the rest did not, they will go up from 30% to 50%. And then when they sell off that 50%, the valuation of that 50% would be equal to actually the money that they have paid for the 30%. So that's how it happens. Again, it's a soft right. You cannot sort of take it up in a properly documented manner, but that's something that, you know, is a part and parcel of doing transaction in India.
Okay, thanks a lot. That was indeed very helpful and insightful for all of us. It was wonderful to have you here. Is there anything else that you would like to add in the end?
Nothing further from my side. I think I'm sorry. I think frankly, a session like this is impossible to cover in just an hour or 45 minutes. But I have tried my best. In the event, if you or any of you have any specific questions or wish to discuss anything, my contact details would be with Tulip. I think Tulip, if you could just share everybody my contact details,
Yeah,
email ID. Feel free to sort of reach out, and I would be happy to sort of help anybody. Thank you so much for your time.
Yeah, thanks a lot, and it was very profound and an excellent session. And thank you for the attendees to Legitquest YouTube channel. Thank you. Just dropping out the ID here. Thanks.
Thank you. Thanks.